But let's begin with the acquittal of those 5 former World Junior Hockey players of sexual assault. The judge, Madam Justice Maria Caracia, determined the evidence from the woman at the center of the trial, known only as EM, lacked credibility. Michael McLeod was the only one of the 5 to face 2 charges. He was found not guilty of sexual assault and not guilty to being party to an offense for facilitating assaults. Cal Foote, accused of doing the splits over EM's face. The judge, in a lengthy judgment with lengthy description of the reasons, said the Crown didn't prove there was contact or that the action was sexual in nature. Dylan Dubé had been accused of obtaining oral sex from EM. The judge says she did not find beyond a reasonable doubt that was non-consensual. Alex Formanton's case, the judge found that EM expressed a willingness to engage in sexual activity. The judge pointing out consent can be communicated by words and conduct. And for Carter Hart, Judge Caracia said the Crown failed to prove beyond a reasonable doubt that EM did not consent to oral sex. As we mentioned, the judge says she didn't find EM's evidence to be credible or reliable. She said that EM exaggerated her drunkenness during the night in question, filled the gaps in her memory with assumptions, and shared what she described as her truth as opposed to the truth. As a complainant in a sexual assault trial, EM's identity is protected, of course, by a publication ban. She watched the decision remotely, and here's how her lawyer reacted to the ruling outside of court.
She's obviously very disappointed with the verdict and very disappointed with her Honor's assessment of her honesty and reliability. She's really never experienced not being believed like this before. She chose to persevere and continue with the process of seeking justice. She knew there were no guarantees for guilty verdicts, and that even if she decided not to testify, that decision would have been accepted. But she felt that it was important to see the process through to the end, even if it meant opening herself up to intense scrutiny and unjustified criticism.
The lawyers for each of the players spoke. They didn't answer questions, but expressed their satisfaction with the process and relief on their client's behalf.
The damage to Mr. McLeod's reputation and his career has been significant. But today's decision begins to restore what was very unfairly taken away from him.
A criminal trial is rarely an opportunity for vindication. Here it is. It is both gratifying and unsurprising.
The impact of this case has changed Alex as a person, and he's matured well beyond his years.
This decision comes as a result of careful deliberation by Her Honor. She engaged with the evidence in a thoughtful, methodical, and principled manner.
7 years ago, Cal was 19. He is now 26. That is a significant part of a young man's life. He is still young. He has a wonderful future ahead of him, and he is eager to embark on his next chapter.
Meagan Fitzpatrick watched the proceedings from a second room at the courthouse. And Meagan, it's been a long day. Take us through what it was like to watch this, judge's decision, because I know it went on for a long time.
Yeah, good evening from outside the courthouse, Ian. And what's happening here right now, supporters of EM are here holding a rally. And we just heard from the lawyer who had been representing EM. You played the clip of her just now, and she was just addressing the supporters here. She called the decision by Justice Caracia highly disturbing. We'll talk more about that in a few minutes, but let's talk now about how the day unfolded, and it was a long day. Court got started around 10:30 this morning, Ian, and it did take hours for Justice Maria Caracia to read her decision, but near the top, she gave an indication of where she was going when she said, in this case, I have found actual consent, not vitiated by fear. I do not find the evidence of EM to be either credible or reliable. She went on to say, with respect to the charges before this court, having found that I cannot rely upon the evidence of EM, and then considering the evidence in this trial as a whole, I conclude that the Crown cannot meet its onus on any of the counts before me. So that kind of set the table for what we then heard over the next couple of hours. And during her ruling, the judge reviewed some of the key pieces of evidence that were presented at trial, and some of that evidence included the testimony of EM. It included the testimony of Carter Hart. He was the only one of the 5 accused to take the stand, and she reviewed other pieces of evidence and gave her assessments of that evidence. She reviewed the positions of the Crown and of the defense, and of course at the heart of this case was whether the sexual activity that happened in that hotel room was consensual or not. The judge said in her ruling, Ian, it is not the function of this court to make determinations about the morality of the conduct of any of the persons involved. It's the function of the court to determine whether the Crown has proven each of the charges against the accused beyond a reasonable doubt. And the judge highlighted some of the issues she had with EM's testimony, calling some of it troubling, saying on several occasions EM referred to her evidence as her truth rather than the truth, which seemingly blurred the lines between what she believed to be true and what was objectively true. In the end, Ian, it boiled down to the Crown failing to prove its case on each of the charges, the judge said. Each of the men were facing 1 count of sexual assault, with Michael McLeod facing that 2nd charge of being party to a sexual offense. Near the end, the judge stating that she was finding each of them not guilty, and she said the accused were free to go. They then were free to go and freely walked out of the courthouse right here, Ian, and left, getting into cars. And some of EM's supporters who were here heckled them and yelled at them as they left the court. And we do know now the Crown has 30 days to file a notice of appeal if they want to try and challenge any of the judge's findings.
Yeah, a quick question about inside the courtroom, and you were in an overflow room, but basically we're watching things live remotely. How long did it take the judge to go through her reasons?
Well, it started around 10:30 this morning, and it didn't wrap up until I think it was about 3 o'clock or so. At one point, court did take a break. During that break, the accused were out in the hallway with their lawyers and their family members who were in the court with them today. So yeah, I think it was mid to late afternoon, Ian, by the time she finished reading her lengthy decisions.
Yeah, so it's online now, so anyone who's watching who wasn't able to be in the courtroom or the overflow room and is interested in this, they can read the entire reasons online, and it is a detailed sort of assessment of the evidence, of the law here. It is quite an extraordinarily detailed judgment. Now, we heard on this program clips from the lawyers for EM and for the players, which the lawyers were speaking just outside the courthouse. Tell us more about the reaction as they spoke.
Yeah, there was a big crowd here, and speaking of the overflow rooms, those existed because there was such a crowd here to watch the proceedings today. So the lawyers did come out one after another, and both the Crown lawyers and the defense lawyers. And I want to play a little bit of what we heard from the lead Crown attorney, Meagan Cunningham, and her reaction to the judge's decisions. Let's take a listen.
A successful prosecution is not measured solely by whether there are guilty verdicts at the end. The Crown's goal throughout this proceeding has been to see a fair trial. A trial that is fair to the men charged, and one that is also fair to EM. We want to thank EM for coming forward and for her strength in participating in this process.
So the Crown thanking EM for coming forward, and we heard from EM's lawyer that she wanted to thank the Crown and her supporters. And we heard there from the defense lawyers as well in those clips. They are describing their clients as grateful and relieved and saying they want to get on with their lives now, talking about the toll that it has taken on their lives. And just lastly, Ian, in terms of other reaction that we're tracking, we do have a statement from the NHL. 4 of the 5 players were in the NHL at the time the charges were laid in 2024, in January of 2024. Here's what the NHL says. The allegations made in this case, even if not determined to have been criminal, were very disturbing, and the behavior at issue was unacceptable. We will be reviewing and considering the judge's findings while we conduct that analysis and determine next steps. The players charged in this case are ineligible to play in the league. So that's what we're hearing from the NHL. We've also seen a statement from London Police as well. if we have time to get into it, they had initially opened an investigation soon after the alleged assaults, which date back to 2018. They conducted an investigation and then closed the case without laying charges in 2029. Then they reopened the case in 2022 after this became a national story and it became known that the complainant had filed a civil lawsuit. And then London police reopening the investigation, charges being laid in 2024, and this trial taking place in 2025. It started in April, lasted 8 weeks. One of the defense lawyers suggesting today when they were reacting, Ian, that the London police made the right call when they initially didn't lay charges, but again, they had reopened it and laid the charges. So that's a bit of the reaction so far. And again, we're tracking this rally here. We can hear the supporters chanting and yelling that they believe EM.
Meagan Fitzpatrick live at the courthouse in London, Ontario, and believing the complainant, another one of the things that the judge talked about in her reasons for judgment. Let's get some more legal analysis. Phillip Millar joins us now, former Crown prosecutor and principal lawyer at Millar's Law. All 5 of these former hockey players found not guilty. And were you inside the courthouse for this?
I was not inside the courthouse, but I was monitoring it through the secondary room.
Okay, so you were in that overflow room and heard the judge as she went through her reasons for judgment. What should the public know about what happened in that courthouse today?
The public should know that the rule of law took precedence over social coverage that essentially positioned these 5 individuals as guilty until proven innocent, to use a vernacular. The public should know that the rule of law succeeded today, that an objective, very well-respected judge listened to the evidence, and the verdict is of no surprise to anybody that was aware of this case. This case was pushed forward on a social agenda, and the case wasn't covered. The bad evidence of EM wasn't covered. It just seemed to be a constant regurgitation of this believe all complainants narrative. And so anybody who is surprised or upset really needs to pay attention to how bad the evidence was. The original police officer who did the investigation, everybody knows inside of the police force that he did a great investigation when he recommended no charge. And I think the public needs to know or ask, why did this charge come forward? Why did we spend millions of dollars? And will there be a lawsuit by these 5 hockey players to go after essentially a prosecution that seemed more interested in social activism than justice?
Some people are going to hear your answer and be shocked by it and wonder about your own motives in terms of how you feel the justice system should be dealing with complainants in a sexual assault trial.
Yeah, well, I represent many complainants in a sexual who have been assaulted. I represent about 20 against the Canadian Forces. I represent them across Canada. And I've been in front of that judge in a civil lawsuit where an accused was found not guilty, and in my civil lawsuit found him to be liable and gave a giant verdict against him. So this judge is very responsive to victims who have credible stories. But what we saw today is a judge with the courage to say, you weren't believable. And it's as simple as that. People don't want to talk about it. And the advocates behind this are essentially telling the public, you have to believe everybody who says anything happened, or else the system is broken. And that's not the case. Sometimes the case is not good. Sometimes people are exaggerating for a lawsuit they're going to do after against rich hockey players. So that's why we need to let the justice system work before we pronounce guilt in the media, before evidence under oath can be heard.
You know, I mentioned this before, for the people who weren't able to actually see what happened in the courthouse, they can read the entire reasons for judgment. And I went through the judge's assessment before this program of the evidence. And so, you know, the headline is that she found EM not to be credible. The details are what struck me as a kind of a meticulous review of the evidence. But how would you assess how the judge assessed the complainant here?
Judges they have a very, very tough job because there's pressure, there's indirect pressure, there's direct pressure to keep the public happy. It takes a high degree of courage to make a tough call. Being a courageous person means making the call that the public or the media might not agree with because they don't know the details. But that judge did a spectacular job of recounting the evidence. And like when it comes to consent, this is the big issue. And you essentially can't say that drunkenness vitiates consent when you're just self-reporting. I think one of the key things I found is the judge felt that she actually had the ability to consent and that the drunkenness was exaggerated, and she found that troubling. That's very important when we deal with that issue of consent when people's lives are on the line.
There are people who are saying publicly on social media and other media that this case, and in particular this verdict, is a step backwards for sexual assault survivors. What would you say about that?
I would say that the prosecution by the Crown Attorney's Office was a step back for real survivors, because the prosecution knew how weak the case was. And they went ahead and acted more like an advocate than a minister of justice. And when we push forward cases that aren't good cases, that shouldn't be charged in the first place, it hurts the real victims, right? But if we say we believe everybody who makes a complaint, then it dilutes the real cases. And we have to get a grip on reality. You just don't believe something somebody says because of their gender. You believe them because of the evidence, because of the scenario. And I think that's what you see a lot of people who are making money off of this industry, whether they're public interest groups or lawyers. We have to have this dispassionate legal system that puts innocence and evidence at the forefront. And those men's lives were destroyed. They were treated as guilty in the media before it happened. That's the crime. It's not that somebody who had a story that wasn't believable, that the original officer said there's nothing there to charge, right? The crime is that the system spent so much money on this trial and it was made into a circus.
Phillip, thank you very much for your perspective.
You're very welcome. Yeah.
Principal lawyer at Millar Law in London, Ontario.